rise. The Court of Appeals Division 1 is now in session.
Please be seated. This is the time set for argument in 1 CA JV 20-0273, Roger S. versus James S. Counsel, we have read the briefs in this matter. We've also conferenced the case in conference this morning. Keep that in mind as you do your presentations. Each side has 20 minutes to present their arguments here today. Please do so at the podium near your table. You may remove your masks when you're doing your presentation. Because the case is being recorded, please state your name and the party you represent before you begin. And with that brief introduction, we'll hear from counsel.
Good morning, Your Honors. Erica Padish-Conrad on behalf of Roger F., the appellant. May it please the Court. We are here today because the appellant, Roger S., whom I will also refer to as the legal father from here on out, appeals the trial court's order setting aside his judgment of paternity and deeming James S., the biological father, to be the child's father. It's undisputed at the time of the child's inception, mother engaged in intercourse with two individuals, the parties involved in this matter. However, she resided with Roger during the course of her pregnancy. The legal father continued her relationship with him, and both her and the legal father acknowledged the paternity of the child on the birth certificate. This was filed with the state, affecting it to be converted into a judgment by law pursuant to the statute. DCS subsequently became involved and acknowledged Roger as the father as well. James, the appellee, then attempted to establish paternity. Although he knew mother was pregnant 3 months into her pregnancy, case law is clear and individuals on notice of a possibility of pregnancy when they engage in intercourse. The courts are also clear this cannot be used as an excuse for mistake, fraud, or misrepresentation when it comes to paternity rights.
Oh, I'm sorry. Mistake? It's not a given just because one person is having sexual intercourse that they're going to become a parent. Isn't it always a mistake if they believe they're not the parent? Obviously, mother in this case was mistaken.
Correct, but the statute that handles paternal parent father's paternal parenting rights states that it's not a mistake. You cannot use the excuse as a mistake if you've engaged in intercourse.
It says it. And what statute are you referring to? Because the statute specifically says that you can allege mistake, fraud, or duress, correct?
That's correct. But in this case, father...
It doesn't define mistake, does it?
It does not define it in the statute. But it's known in case law, and as well as when the punitive father's registry defines mistake as that it cannot be considered a mistake if you've had intercourse. You know that there's a possibility that the mother could be pregnant.
But you're still losing me because he may have known that he had intercourse, but the mother in this case, we're assuming that she was being truthful, aren't we? That when she says your client was the father?
Yes,
okay.
But she's not alleging mistake.
Then she was mistaken, right?
But the father, in all cases, the father is known if he's engaged in intercourse, there's a possibility that she's pregnant, and she was pregnant and he was aware of it. So a mistake...
He's mistaken because he's relying on her representation that he is not the father.
He's assuming that he's not the father.
Well, he's relying on that representation.
That's correct, but that's not enough. That doesn't meet the standard to...
Well, what mistake could you possibly ever have then?
He, as a man who engaged in intercourse, with a woman, he was under the responsibility, if he believed that there's a chance that this could be his child, then he cannot allege mistake. Roger S., my client, the legal father, presumed that it was his child.
With that standard, then you're reading mistake right out of the statute when you says you can file challenging based on mistake, duress, or fraud. I mean, there's no allegation of fraud here,
Right.
correct?
Correct.
Or no allegation, is it duress?
Duress.
Yeah, the only allegation here is mistake.
Correct.
And I see a lot of mistake. Mother's mistake on believing who was the father, his mistake on relying on her representation that he was the father. Why isn't this a simple mistake case?
Well, the legislature sets time limits for challenging parental rights, and they do that for a reason, because they favor finality when it comes to parents' rights and children. They unambiguously express a preference for this, and it's not in the best interest of a child for someone to come in and challenge paternity after a legal father has been established. Legal father has taken all of the right actions. He continued the relationship with mother. He's financially provided for this child. He was present at the birth. After discovering the DNA evidence of the biological father, he encouraged and fostered the relationship with the biological father. The biological father's only reasoning for the mistake was he knew that there was a possibility that there may be another father. This isn't the standard to prove fraud or mistake or duress under Rule 85.
Okay, let's go with the time limit for a minute. What the statute says, you have to file any time within making this allegation within, according to Rule 85.
6 months.
And 85 is where the 6 months comes in.
Correct.
And didn't he file? He filed that motion to intervene alleging that he was the biological father within the 6-month period, correct?
He did file it within the 6-month period. However, there's a voluntary, because the parties were not married at the time the child was born, the voluntary acknowledgement in the birth certificate fall under Rule 25-812. And that gives you a 60-day time limit for challenging the paternity. And he did not file in time for that.
Oh, that only goes to the parents who were on the birth certificate.
Correct.
Well, he wasn't on the birth certificate.
No, he was not. He filed a motion to intervene, then the court changed the motion to intervene into a petition for paternity.
And why can't the court do that?
Because he did not plead the facts that you are required for a petition for paternity. And in order to file for...
What was missing? He said he didn't plead the facts, but he said, I'm the baby's daddy, and here is the proof.
Well, there's a pending judgment because of the birth certificate and the voluntary acknowledgement. In order to do a paternity action, you can't have two judgments outstanding. So the proper way to do it would be to file a motion to set aside the current judgment of the legal father, and then motion the court for paternity.
But I'm missing, what more did he need to include in his pleading than what was
All he
there?
provided was DNA results, and he didn't request the court declare him the father in his petition to intervene. All he did was just ask to intervene.
Why was he motioning to intervene if it wasn't to become the father of this child?
Well, we don't know because he didn't plead it.
Okay. Assuming that the rule allows, I think it's Rule 24, that allows the court to treat a pleading even though it's mischaracterized, that was sufficient for this to be treated. Does he otherwise, he's come within the 6 months, he's alleging he's the father. What is missing from the pleading that would put your client on notice that he needed to defend this action?
The requirement that the initial judgment of the legal father be set aside before consideration of the biological father come into play. So really it's a procedural matter here, and there needed to be a petition to set aside in a separate matter before the petition for paternity can be addressed.
And did someone raise that below?
Yes.
Okay. And the judge said?
The court, I was not involved below during litigation, but I know from the pleadings in the court's rulings that it chose to take the matter and just combine it for efficiency's sake and not rule on the prior judgment.
Okay, and is there something wrong with doing that? Was that an abuse of discretion to somehow say, I understand what everyone's asking, and instead of making you go through those steps, I'm going to assume that this is what's happening and put everybody in the same procedural posture as they would be had they asked to set aside? Was that an abuse of discretion?
Well, my client was never able to testify in this case. He was present at every hearing. He was present and responded to every matter during the whole course of this litigation. The only time that he wasn't was during when the judges changed courtrooms and he was given the wrong Zoom information. So he wasn't present when the court declared biological father to be the biological father and take away my client's rights. So at the very minimum, we would ask that this case get remanded to the trial court so my client has at least a chance to put on evidence and the trial court be fully apprised of the situation before they take away a parent's rights who has been acting as the legal father.
Did he notify the court after the court entered the paternity judgment against him? Did he notify the court that this is the reason why I wasn't present?
It's my understanding that he did, and his attorney was trying to call him. There's a transcript of his attorney trying to call him during the hearing. He had no reason not to be there.
That's what I remember, is they were trying to reach him.
Right, and it was a Zoom call.
Right, but they couldn't reach him.
They couldn't reach him
His own
because he was on
attorney
the
couldn't reach him.
right, because he was calling into the wrong line.
But that wasn't my question. My question is, after the fact, is there anything in this record that would indicate why he wasn't present?
Simply because of the transcript that we have and.
But that transcript only shows that he wasn't present and they tried to get a hold of him. If he was sitting in the wrong courtroom, that would be pertinent, and the judge certainly may have wanted to know that. But is there anything in the record that would indicate the juvenile court who entered this judgment was aware of that fact?
Not at the time they entered the judgment.
How about after the judgment was entered?
I'm
There'd be a
not-
motion to set aside or some type of
Reconsider,
motion.
something
Right.
to alert the court that this was not because he didn't want to be present, but because there was technical difficulties. Was there anything below that, in the record, that would show us that that happened?
Not in the record. As the court in McClellan held, a presumptive father has no logical effect when a child has a legal father. Finality is favored by case law and the legislatures who drafted the statutes. Here, legal father has been a responsible, accountable, dependable father. He's been respectful of the relationship, and to disturb it would only hinder the relationship with his family to the detriment of the child. This court should uphold the statutes with legislative intent in accordance with McClellan. The legislature vested the courts with powers to make rulings pursuant to 25-812 and 25-814 when it comes to challenging paternity. Mere presumption of paternity, as set forth in 25-814, are subordinate to the establishment of paternity vested by 812. At the bare minimum, the legal father should have a right to present evidence and represent himself when the court makes this determination. Had the legislature intended otherwise or expected courts to convert motions to intervene into petitions to establish paternity after the time prescribed, they would have. They didn't put it in the statute. The case Brumman attempted to set forth policy reasons why voluntary acknowledgement should not be treated as a judgment, contrary to the statute. Sometimes the biological father has no knowledge in some cases. That's not the case here. McClellan correctly held the legislature made a different determination that after the 60-day period set forth by statute, it does become a judgment. And it's well settled that this court has determined it will not second-guess legislative intent. Therefore, in order to set aside a judgment, a party must do it pursuant to Rule 85. The mere presumption that he might not be the father does not meet the standard of Rule 85 to be considered a mistake. He acknowledged the pregnancy.
That's not really all there was here, right?
That was the only reasoning he gave, is that he might not have been the father and he didn't know.
But wasn't mother telling him he wasn't the father? And didn't he have another party who said he was the father?
So yes, the other party said he was the father. Mother and him lost contact after the first 3 months of the pregnancy. They didn't talk until mother later contacted him after the child was born. We respect.
Can we really fault him at this point in time? He goes by, he sees the kid, he thinks, oh, that kind of looks like me. He gets a home pregnancy test. He has it done, and as soon as he, pardon me? Home paternity. It's been a long morning. He gets a home paternity test, comes back, it says, yep, you're the dad. And almost within a matter of a very short amount of time, he files the motion to intervene, right?
Yes, but he was aware of her pregnancy the first 3 months of the pregnancy, and he was aware of his relationship with her during that. The parties broke up, split. He chose not to follow up and ensure that he's the father or not the father of the child.
But he did it within the time frame set forth by the rule and the statute, correct?
Not by the statute, by the rule.
Well, the statute says at any time pursuant to Rule 85.
Well, 812 for the voluntary acknowledgement only gives 60 days.
For the parties on the acknowledgement.
Then after 60 days, then it becomes a judgment under 25-812. And in order to challenge a judgment, then you would have to do a motion to set aside the judgment and file the rule through Rule 85C. So procedurally, he was off here.
I'm still missing something when you say procedurally is off, because under the statute, it says a mother or father may rescind the acknowledgement within the earlier of 60 days or the date of a court proceeding concerning the child. Then after 60 days, paternity can only be challenged based on fraud, duress, or material mistake of fact.
Correct.
So since he wasn't on the acknowledgement, and so it became effective, as you said, but then clearly he is arguing there was a material mistake of fact because I'm the dad.
That's correct.
And he did that timely because he filed it within the time of Rule 85B, was within 6 months.
Well, he filed his motion to intervene within 6 months. And then the court later, after the 6 months, converted it to a petition for paternity. So it wasn't a Rule 85 motion to challenge in the 6-month period.
So is it your position then that this case rises or falls on the label that he put on his motion to intervene? If he'd have just labeled it motion to set aside judgment, then he's okay.
Procedurally, it did not follow the rules that the legislature set forth and that are prescribed by our statutes. And so procedurally, yes, he missed the deadline and titled it incorrectly. So we respectfully request you remand this to the lower court and allow a legal father to present this evidence and testify. We believe after this, justice will be served and the court will be able to make the most equitable decision for all the parties involved.
All right.
Thank you.
Want to reserve the remaining of your time for reply?
Yes, Your Honor.
All right, you may do so. Counsel?
Thank you. I'm Edward Johnson here on behalf of the biological father and current placement, James S. Retired Judge Patricia Norris once told me, children are not commodities. May it please the court, we are requesting that this court affirm the Superior Court's decision in this case. Judge Norris's words are powerful, significant. Children are not chattel. We live in an amazing time, so many technological advances, it's easy to lose sight of the forest through the trees. We must remember that we're here today for a young child, not yet two. The decision made today in this building will affect her life profoundly. The child is currently living with her biological father and has been since November the 2nd and is doing quite well. We live in a society today where people yearn to learn about their ancestral history. DNA is readily available to all those who would like to find it. Imagine a world in which this young girl, now an adult, grows up and she reaches out on DNA to find out that her father listed on the birth certificate is not her biological father, but instead she has a biological family that she never knew of. And
So wouldn't that have been the end result had your client filed this, whatever we're going to call it, 3 months later?
I don't believe so. So I had that thing. Just to clarify a couple of things. The statute quoted the 60-day, you're put on notice when you have sexual intercourse, is 100% accurate for an adoption. That's the putative father registry, and it says you're put on notice if you have no right to argue if the child goes up for adoption. That's not what we have here. We have here a father in James S. who was knowingly involved in a love triangle. Everybody knew it. The record shows that Roger S. and James S. communicated via phone and via text messaging. The agreement was that no father would be put on that birth certificate until a paternity test was completed. James S. was under the assumption, based on what mother had told him, and this is the uncontroverted evidence from the hearing dated August 28th, that mother was not going to put anybody on that birth certificate until the DNA test was completed. That didn't happen. It's important to note that he didn't even know mother had the baby. She had told him she was due in August, the end of August, beginning of September, when the baby was born early. This baby was already 5 to 6 weeks old when he learned about her. He immediately went to her home. Importantly, had to bring a friend with him because of domestic violence concerns with Roger S. Mother didn't want him to come by himself because neighbors were watching. That was the testimony provided. He brought his friend Kim with him, saw the baby, and immediately realized she looked just like his daughters. He immediately took the mom, the baby, got the paternity test completed, had to wait several weeks for the results to come back. So why didn't he intervene at that point? The testimony is because he was worried about mother's safety and well-being, that there was so much domestic violence going on, that Roger S. was so controlling. He was worried about opening up Pandora's box if he wasn't the father. He didn't want to put mother in that situation. He gets the results December 1st. December 2nd, he files a motion to intervene and requests custody of the child. It's in the motion to intervene. He puts the parties on notice. He's requesting custody of the child and attaches the paternity results. He did what he was required to do. Could he have done it in the family court? Absolutely. But why didn't he? He testifies because he knew the open DCS case was there, and that's where the child was pending. And our statutes say it's clear. For judicial economy, that's what you can do. The juvenile court takes priority over all other courts. He could have filed it in the family court. That would have been kicked down to the juvenile court to divest jurisdiction there. So he chose to go the direct route with Judge Warner. Judge Warner said, we're not going to let you intervene yet, and asked DCS to put in a more official paternity test, I think, just out of an abundance of caution. So to answer your question, I don't think that the results would have been different. I think he did what was reasonable, and he did what he thought he needed to do to assert his parental rights in this case.
But the rule has a 6-month deadline, correct?
It does.
So if he had missed that 6-month deadline, he'd just been out.
Well, and I respectfully disagree. I think he would have missed it if he was challenging under fraud, duress, or mistake of fact. But I think the case law and the statute is clear. There's still a catch-all. There's still B6 that he could have tried to challenge it at any point in time. Obviously, that just wouldn't really work in a situation like this when mistake or fraud are really the only vessels that he can make that possible.
Except the statute limits it only to those three.
To which three? Fraud?
Fraud, mistake, or duress.
But there's also under B6 the...
Yeah, but that's not what it says, does it? It says only as it relates to fraud, duress, or mistake pursuant to Rule 85. So it doesn't say, or any other catch-all phrase in 85. It says only.
Well, I interpreted that different, Your Honor, if I may, 1 second. So actual Rule 85C covers the timing and effect of the motion filed under Section B. 85B, there are the 6 individual grounds for relief, including the fraud, mistake, but also includes any other reason justifying relief.
The statute reads, may challenge a voluntary acknowledgement of paternity established in this state at any time after the 60-day period only on the basis of fraud, duress, or material mistake of fact.
My apologies. You're correct. Well, luckily, I think here we have the mistake. I think Judge Bustamante's order is very clear, and where one might have argued that there was fraud at some point by somebody, that it wasn't fraud, it was a mistake. That the father, Roger S., was added to the birth certificate and shouldn't have been because they all knew about each other's existence. And the pertinent thing to do would have been to wait for the paternity test results and have the appropriate father put on there. But that didn't happen.
Okay, well, clearly there was a mistake. What does it mean to say a material mistake? I mean, there was a mistake, sure, somebody was wrong. But are we to read the phrase material mistake as more than just, oops, we got it wrong?
A great question. I read a material mistake as something that is significant in the outcome. And I think adding the wrong person to a birth certificate when he's actually not the father is significant in the outcome. They didn't spell the name wrong. They didn't, have some issue there, which I would consider not to be material. This is a material mistake, and the wrong father is on the birth certificate when he's actually not the biological father of the child. I'd like to say that Judge Bustamante penned a great decision that was constructed in a way that walked through the requirements to set aside the acknowledgement of paternity as required prior to establishing the paternity of James S. It's clear in her ruling that even erring on the side of the mistake and not the fraud, the just result for this child is that James S. is, in fact, her lawful legal father as well as a biological father. James S. did what he needed to be done. He got the results on December 1st. He went to the courthouse on December 2nd. He didn't wait. He took action immediately to establish his paternity. Your Honors, children are not commodities. We'd ask that you affirm the decision from the Superior Court. And I would like to just clarify 2 quick items. The transcript from the August 28, 2020 hearing on page 32, line 11 through 13, Father Roger S.'s counsel, the court asks, Mr. Bierling, go ahead. Mr. Bierling, my client testified at the previous proceeding, Judge, so I don't have anything further. He did not ask to set aside his client's non-appearance. He didn't ask for any other outcome with that. He told the court, my client has previously testified, nothing further to offer. The record was clear. He did try to get a hold of his client and was unable to do so, but that certainly shouldn't have an outcome on today's proceedings. And with that, if you have any additional questions, I'm happy to.
All right. No, thank you very much.
Thank you, Your Honors.
Counsel, any final words?
Yes, just one follow-up issue. We have no evidence of these text messages or conversations between the parties during the pregnancy, but that's further evidence that biological father was aware that there's a possibility that he could be the father, and he chose to not act on it. Inaction does not meet the burden of a mistake under Rule 85. To hold that would do disservice to the standard that the standards set forth and reward someone who knowingly fails to act.
Thank you, counsel. The matter is deemed submitted. We'll issue a decision in due course. Thank you very much for your briefing and also for the briefing from the amicus. Court stands at recess.